You know, you don't have to take an oath here in Idaho. You simply need to put yourself in the same jeopardy of perjury if you lie as you would be if you took the oath. The kind of ceremony that you go through is really not relevant. You don't have to jump up and down and drink goat's blood under the full moon to attest to the fact that what you're going to tell is the truth. And in addition to that, most, people, when they take the oath and they swear and they go through this little ceremony, will then get up there and make misstatements or sometimes deliberately lie anyway, even though they've taken the oath. So I don't think the oath is necessarily the criteria or indicia that's going to compel people to tell the truth. And another problem, of course, is that who's going to summons or subpoena God into the courtroom and cross-examine God as to whether or not I told the truth? So the ceremony is really superfluous. It's something that's written into the rules, and it's something that a lot of people adhere to, and if that's what people want to do, I don't have any complaint about that. I just don't want to do it, and I don't want to be compelled to. And I'm contending that I have that right. So we came into the deposition, and I brought with me all of the file folders and all of the information that they had summoned and subpoenaed. And I was ready to testify, and the very first question that came up was, "Will you be sworn, Mr. Gordon?" Well, I think we can cover that, gentlemen, this way. No, I won't be sworn, but I'll gladly place myself in the same jeopardy of perjury as anyone else would if he did take the oath. Remember that one of the issues of this case is my religious freedom and my abhorrence of swearing an oath or making an affirmation. And then they brought out Rule 37 and Rule 43, and he said, "Do you realize that the rule says that you shall take the oath, and that you shall be sworn, and that if you're not, your case may be dismissed? And do you want to risk that, Mr. Gordon?" "No, I really don't want to risk that, sir." And I'd like to reiterate my position. One of the key issues of this case is whether or not I can be thrown in jail and punished for my religious beliefs and my constitutional rights. Now, I'm here today, gentlemen, with all of my papers, and I'm ready to answer all of your questions, and I'll tell you the truth as to the best of my knowledge, and I'll recite all of the facts to the best of my knowledge, and I will accept the voluntary jurisdiction of jeopardy of perjury, and I'm happy to do that, and I'm going to do everything I can to help you gentlemen obtain all the facts that you need, but I'm not going to swear. I'm not going to go through any religious ceremony. And so he looked over at a colleague and he said, "Now, Mr. Jones, or whatever his name is, can you proceed under these conditions?" And Mr. Jones said, "Absolutely not. If Mr. Gordon will not be sworn pursuant to the rules and pursuant to the laws of the Federal Rules of Civil Procedure, why, I absolutely cannot go forward, and I'm going to file a motion with the court and move the court to dismiss Mr. Gordon's action on these grounds." And he went around this big table and he asked all these prestigious lawyers what their position was, and they all echoed this first lawyer, and we got back over to the moderator there, the head Pharisee there, the head Sadducee there that was directing the Sanhedrin in this inquisition, and he said, "Well, we're going to refuse to ask you any questions and refuse to accept any of your testimony, Mr. Gordon, because you're not sworn under oath as provided by law, and we're going to move for dismissal." And he just read me the riot act and pointed his finger and he just told me which end is up. And when he got all through, I said, "Well, gentlemen, am I excused? May I leave?" And they kind of stood there like, "Huh? Well, I guess I take it that I'm excused. You have no further questions. Is that your position?" "That's right. We're going to let the court determine whether or not you can do this." "Okay." And so I left. Let me show you the crucial issue that's going to have to be decided by the Supreme Court of the United States before we can ever go to trial. And that's this. Let's suppose that I'd walked in there, raised my hand, and I was sworn. Now I've lost my case, haven't I? Because if I could walk in and be sworn today, why couldn't I have walked into this judge's court and been sworn last year? You see, I don't have a religious belief, do I? Now, on the other hand, well, why couldn't they accept the voluntary jurisdiction of jeopardy that I volunteered into in case I lie? They're not concerned about whether or not I lie. They know that I tell the truth most of the time. Their concern was, if we were to allow him to testify in this deposition without taking the oath, which is the issue of this case, well then, why couldn't their client accept my testimony without the religious ceremony of the oath taking? So you see, it's a catch-22 circumstance for both sides, isn't it? On the one side, if they accept my testimony without the oath, it shows that my position's correct and that my religious rights under the First Amendment have been violated. And if I walk in and take the oath, then it shows that I don't have any religious principles with which to defend, and so therefore I was in contempt of court and the judge put me in jail properly. Now, let's take it to the district court judge. He's going to have a real problem in making this determination, isn't he? Because however he rules for the winner. Now watch how this comes down. We walk into the judge and we're going to have an answer. You know, my opponents are going to file a motion to dismiss, and I'll have 10 days to answer it. And I'm going to answer the motion to dismiss, and then we'll have a motion hearing, and I'll be brought up before the judge, and the judge is going to say, Mr. Gordon, I want you to show cause as to why I shouldn't dismiss your action because you wouldn't take the oath pursuant to Rule 37 and 43. And my response is going to be, thank you, Your Honor. I'm glad you asked me that question. And 2 hours later, I will sit down and say, that's why. Now, what is my argument going to be? My argument is going to be based upon Owens versus City of Independence and a case called Butts versus Econo-U and Fort Howard Paper Company versus Sanitation District. You know, one of the issues on the oath is pursuant to Rule 37, where it says every witness shall be sworn. If there's a constitutional question involved, the Fort Howard Paper Company says, or this case says, that the word shall may be, or it shall be, or you have to construe it to be the word may. Must, shall, and may are synonymous terms at any point or over any question of constitutionality. Well, I'm raising a constitutional question, and I'm going to compel the judge. I'm going to say, Judge, I want you to compel these people to accept my testimony without the oath because of the Fort Howard Paper Company case, in which the word shall in Rule 37 must be construed as may. George Gordon may be sworn, which means George Gordon may not be sworn. That my First Amendment rights must take precedence over a simple rule of procedure in a civil matter. If the judge rules in my favor, the next breath is, all he needs to do is to assign or to award me the damages, because if I don't have to be sworn in front of that court to testify, I don't have to be sworn in front of any court. And therefore, any court that puts me in jail because I've asserted a religious principle or a religious freedom has violated my rights under Title 42, Section 1983. Now, do you follow and do you see how that's been lined out? So the judge will probably say, Mr. Gordon, I'm going to rule against you because you failed to take the oath pursuant to this rule. Now, he'll know what he's doing when he does that, because he doesn't want to make the decision in the case. That will give me my ticket to San Francisco, and I'll appeal to San Francisco on my First Amendment rights to freedom of religion, and that I've got a right to redress of grievance, and I've been denied that because they're trying to compel me to give up my religious beliefs in order to go into court to seek redress of grievance. Now, do you follow the scenario, the logic that's behind this case? What you need to do is to go ahead and read this case with all of its various and sundry addendums. There's about 20 exhibits that are on this case, and I have to prove each and one of my allegations, and so I've simply attached an exhibit, which in this particular instance proves the assertions or the allegations that I'm making in the body of my complaint. I think with this kind of information here, and you can continually update this Title 42 case by simply writing to us at Barrister's Inn, Post Office Box 9411, and asking for the latest updates on the responses and the paper proceedings as this case moves along. And for each and every one of you students, let me show you how I've set this case out. Because there are 20 defendants in this case, we've got to have a large number of file folders. And so if you'll just look here, I've got about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I've got about 10 file folders here. Now, one of the defendants, and I'm not going to use his real name in this case, we'll call his name Schmedley. One of the defendants' name is Schmedley. And he's represented by a law firm called Jones, Johnson, Smith, and etc. All right? Well, every time I get some communication from Schmedley's law firm, I'm going to put that communication in this file folder and keep it separate from all the rest. That way, anytime that this particular defendant, let's say, is dismissed from the case. Now, I'm contending that Schmedley here is an indispensable party to the case. But Schmedley, the court may rule, is not an indispensable party to the case, and as a matter of fact, he has immunity for one reason or another, or his culpability simply wasn't there, and so he'll dismiss this fellow from the case. All right. Now, I can take that file folder and set it over in another pile, can't I? Now, what if, in this particular case, one of the 5 law firms, which is this one right here, which is a little thicker, has filed a number of answers. They not only filed an answer and a number of motions, rather, not answers, they filed one answer to my claim, and this was the deposition here that they wanted, and so they subpoenaed me in for a deposition. And then here's a notice of taking a deposition, ducis tecum. And so we'll get an opportunity, and I'll tell you, this is extremely valuable paperwork because as a student, here you have an active Title 42 case right in front of you, and the most prestigious law firms in Boise, Idaho defending. And we know that these people have been to law school, and I think these are just golden little gems. You'll be amazed at how much you can learn from your opponent's law firm. For instance, if you want to file a notice of taking a deposition ducis tecum, what you do is you file this away. Here's the example that comes from a law firm that charges $125 an hour. We know that these people know how to file a motion or a notice for taking a deposition ducis tecum, so what if you want to take a deposition ducis tecum? Well, here's the outline for you. You know, if you went to this law firm to get this, they'd probably charge you $200 or $300. You're going to get it as a part of the course. Let's take a look at another one. Here's a motion for an entry of an order. Okay? See the examples you get there? This is why I wanted to do this case first, because now I've got 5 of the most expensive law firms in Boise, Idaho, defending on this case, sending me everything they learned in law school and have spent years and thousands of dollars to acquire, and I get it free, because even if they get a judgment against me, they can't collect it, can they? So I'm getting the information, and I put all of the correspondence, that is, all the motions and answers from that law firm, in this file folder. Okay? Now, if at any time I have to answer a particular law firm, or this fellow jumps up, I can get his file folder, and I have in front of me all of that information. This case, before it's completed, is going to be this high in paperwork and documents, and I'm not exaggerating a bit when I say that. All we've done so far is to file the action, and let's see how high this is. It's that high, and all we've done is filed it and gotten the answers back. And we've been motioned up to 1 deposition. Now the next step is a hearing. Then there's going to be 2 or 3 motion hearings, and then we're going to have the trial. And before all of that's done, we'll be up this high. And it's going to be, if you've done any cases at all, and if any of you students are doing a traffic case and you've got your file folder an inch thick now, you know how much paper and how much work you've got involved in this. All right. Now let's turn toward the back over here. I want to show you on item J, it says a notice and demand to reverse a contempt conviction. I want you to take a look at an argument, at a position. And I want you to take a look at the logic, reason, and common sense that I put into this. And then you can sit there and say, boy, that Gordon's sure stupid, boy. If he'd have done this, this, and this, maybe you can see where you can improve upon it. But what I suggest that everyone do is this. Since we know that this is correct and that this filing is correct and what I've done so far is correct, why don't you follow what I've done to this point? If it's dismissed for some reason, as you continue along following this case and taking the updates to it, as you get that information, you'll see where I made my mistakes, where my reason, logic, and common sense broke down. And that's the principle that I've been expounding to all of you. You push me up to the next ledge, and I'll throw a rope down and pull you up. And when I push you up to the next ledge, you throw a rope down and help me get up there. Because we know that not everything that we do can be correct. But every time we make a mistake, it needs to be documented so that we can back up and say, okay, we won't do that again. And we've got the best teachers. If you'll line your cases out like this, listen, you've got all of these law firms over here teaching you the technical aspects through their responses and their replies. Whatever they do, you do. Just like the Japanese, they come over here and they copy what we do, they take it back to Japan, and then they ship it back over here and sell it to us. If that's good for them, it's good for us. And that's the Edison principle. All I'm going to do is find out what they know, and then I'm going to use it against them. Over here on item J, you'll notice that there was a response that I made. It's notice and demand to reverse the contempt conviction. Now, when the contempt came down, I had to exhaust every remedy available to me in the state of Idaho, didn't I? Because although it was a civil contempt, I wanted to show my good faith. I didn't want to just say, well, you threw me in jail, so I'm going to sue you. I went back to the judge and I said, Judge, I think you made an error here. I'd like you to correct your error. And so I started, out comes now the defendant in this criminal action specially and not generally to deny this court jurisdiction of the subject matter. Now I'm talking to the magistrate's court. Over the person and the ability of that court to effect a remedy for the cause that a contempt conviction has been entered without cause and without jurisdiction. Can I prove that? Well, I think I can, because you see, the court doesn't have jurisdiction to throw me in jail in violation of the First Amendment to our federal Constitution. The jurisdiction of that court's contempt powers stopped right there over the religious issue. I'm not contending now, am I, that the court doesn't have contempt powers and they can't throw people in jail for contempt of court. I'm saying you can't throw me in contempt of court if there's a constitutional issue. And so while I'm in the courtroom and the record's turning around, I'm the guy that's over there that has to be the belligerent claimant in person saying, Judge, please don't throw me in jail because of my religion. Please don't put me in jail because I'm asserting my constitutional rights. That's what set the record. Going on, this defendant cannot move this court for the reversal without granting the court jurisdiction. And I contend that jurisdiction must be asserted and proved pursuant to Cooper versus Davis and Vaughn versus Vaughn. So I've told this magistrate's court then, my authority then for challenging the jurisdiction of the magistrate's court is right here. All right, the defense contends that where rights are concerned, there can be no rulemaking or legislation which would abrogate them, and I'm citing Miranda versus Arizona. I contend that when a natural citizen in good faith challenges the jurisdiction of the court, the opposition must overcome the challenge to jurisdiction and add new matter pursuant to Bradley versus Fisher, Osborne versus Bank of the United States. Remember up here, we had to assert and prove jurisdiction, didn't we? Well, then why did the magistrate's court fail to assert and prove jurisdiction and put me in jail before it proved that it had jurisdiction when I timely challenged it? And I'm going to prove that, and I've got the documentation with which to do it. Otherwise, I couldn't make the assertion or the allegation. How can you challenge the jurisdiction of the court unless you know where the proper jurisdiction lies and you know what the proper Supreme Court cases are that substantiate your position? Because failure to substantiate your position is a killer. Don't make statements, don't make allegations that you can't back up and prove. You're better off to back off of the jurisdiction issue unless you know that they don't have it. You're better off not to make the charge if you can't absolutely document it and prove it. I contend that this court has acted without jurisdiction in the instant case, and I'm talking about in this, and I filed this, remember now, in the magistrate's court. This is a filing, and I gave them an opportunity to recover. All they ever had to do is reverse the 2 contempt convictions and say, well, what do we owe you, $50 a day for each day we put you in jail? And I'd have been dead in the water. You see, they would have recovered. Anyway, I contend that this court has acted without jurisdiction in the instant case and has proceeded against this defendant in a summary proceeding using ex parte hearings and refusing to file and accept this defendant's written answer to the complaint and the affidavit of poverty, and refusing this defendant's declaration of poverty in this case by sending said declaration back refused. Okay? That's another allegation I made, is that because I'm poor, should I be punished? Now, I'm poor by choice, and I'm poor by choice because if I were to go out and work, my government would take it all away from me. They did that to me before. And since my government wants to take all of my property away from me, then I don't have any incentive to go out and make any more property. But there's no law that requires me to go out and work and produce. I can live like everyone else. I don't have to be rich and wax to great with increase. Now, here are some facts and background. Then I simply laid out the facts and the background here to the judge, and you can cover that and read it. On page 3 of this particular Exhibit J, I make a few nifty statements in here. Let's break in here at, say, the top of the page on page 3 and take a look at a little what I consider to be logic. To ascertain the intent of the court and thereupon inform the court that he was a pathological liar and could not be sworn because he did not want to be guilty of perjury. I'm one of the few people in the United States that's on record as being a pathological liar, and in case you're one of those, you might want to know how that works. A pathological liar has a disability. It's a medical disability like being an alcoholic. Now, I contend, based upon Scripture, that all men have lied in the past. That's past tense. Are liars today, because sometime today you're going to tell a lie, and that you're going to lie tomorrow. So if you are a past tense liar, a present tense liar, and a future tense liar, you have some kind of a disability. You don't have the capacity to tell the truth 100% of the time. So you're a pathological liar. Now, remember, under the doctrine that we've espoused concerning this question of language, you'll notice that they'll bring you into court and they'll say, do you understand the English language? Well, in my case, no, I don't. And people look at me and they say, well, Gordon, based upon your vocabulary, I would say that you're above average. Well, I don't know if I'm above average or below average. All I know is the question you asked was, do I understand, do I know and understand the English language? And I said no. And the reason for that is that there is 512,000 words in the English language. Now, if you graduated from high school, on average, you'll know 10,000. And if you graduated from college, on average, if you studied languages like the English language or Russian or French or German or something like that, you'd probably have a vocabulary of around 20,000. 20,000 out of 500,000 is 5%. And my contention is that anybody that knows as little as 5% of a subject is a functional illiterate. Remember, when you get on Eastern Airlines down in Miami and you're flying to San Francisco, and you get over San Francisco and the pilot gets on the intercom and he says, ladies and gentlemen, I only understand and recognize 5% of the instruments here in the cockpit. As soon as I'm able to find the flaps, the landing gear, and the fuel flow indicator, we'll attempt an emergency landing. Would you say that the man is a pilot? I would say he's a functional illiterate sitting in the left seat. And I would want a pilot to go up there and sit down and take charge. The fact that he flies airplanes does not make him a pilot. The fact that he flies an Aeronca Champ or a Cessna 172 doesn't make him qualified there as a 747 pilot. And the fact that I speak the English language in some kind of rudimentary fashion, and I'm a functional illiterate, doesn't make me qualified to say to you, yes, I understand the English language. And because I tell the truth 75% of the time does not make me a person who tells the truth or an honest, truthful person. The real fact of the matter is that I went to dinner not long ago and somebody asked me how the meatloaf was, and I said it was wonderful. And then I went home and took 3 Alka-Seltzer. I lied to the lady because I didn't want to hurt her feelings. And I do that all the time, and I suspect that most other people do, although I'm not saying that you're a liar because I don't know about you, I just know about me. And so it's for that reason that I have this medical disability. There's something about me that causes me to lie from time to time. That's what makes me a pathological liar. That doesn't mean I can't testify. That doesn't mean I can't go in the court. I just want to let you know the truth. I'm not going to lie to you and tell you that I understand the English language, and I'm not going to lie to you and tell you that I tell the truth. I tell the truth most of the time. I tell the truth when I want to tell the truth. And I suspect that most of you probably do the same. Now, those are facts. Thy word is truth. When you're really talking about truth, you're talking about Scripture. You're not talking about facts in the courtroom, and I suspect that nobody in a courtroom is really interested in the Bible or interested in truth. They're really interested in facts. So keep that in mind. Going on, I said, the court would not answer numerous questions that the defendant needed answered and cut short the defendant's inquiry and threaten contempt charges if the defendant would not swear upon an oath. Under this threat, duress, and coercion by the court, and in fear of imminent imprisonment, the defendant raised his hand and was asked by the clerk of the court, quote, "Do you affirm that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?" And I answered no to that question, whereupon the judge declared the defendant to be in open contempt of court. Now I want to ask you a question here. Let's look at that quotation, and let's see whether or not I've got any position when I say no to this question. The first thing that comes to my mind is, when you ask a question, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Somebody must need my permission to do something, a contractual agreement, a verbal contract, or else the judge wouldn't even ask me the question, because you see, if he had the power to compel me to tell the truth, he'd just say, "Hey dummy, sit down over there and answer these questions, and if you lie, I'm going to throw you in jail." If he had that kind of power, why would he ask me the question, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, going over this again, it says, do you affirm? Okay, the word affirm is simply a euphemism for the word swear. Now, if my position is that I'm a person who believes in Scripture and does not want to sin, and sin is in 1 John 3:4, it says, sin is the transgression of the law. I'm a law-abiding person. I want to obey Scripture. I want to obey that law. So I can't swear and I can't affirm. Now, if you'll take a look at Matthew 5:33 through 37, Jesus Christ said, when you're asked to make an answer, let your yea be yea and your nay be nay. Now, if you're going to say yes, yes, and if you're going to say no, no. And that's all I want to tell the court. I'll tell you, I'll answer your questions. I won't refuse to answer your questions. I'm just not going to go through this religious dogma here of swearing or affirming. So it says, do you affirm that the testimony you're about to give will be the truth? What is truth? Pontius Pilate had that problem when he asked Christ, well, what is truth? He was a major political leader of his day, and he said he didn't know. The Scripture says, thy word is truth. Well, I don't know all of the Bible, so therefore I can't tell you whether I'm going to tell you the truth, because I don't know too much about Isaiah 24 or Matthew 6 or Revelation 14. There's a lot I don't know. So, first of all, I would like to tell you the facts as I know them, but I don't want to tell you the truth. The whole truth. Who on earth knows the whole truth? Is there anybody out there listening to my voice who's going to stand up here and say, I know the whole truth and I'm going to relate it to you? I've never talked to a scientist yet who claimed that he knew the whole truth about any subject. The best we can do is come up with a hypothesis, transform it into a theory, substantiate it with data, and we think that this is probably true because that. And here's somebody that says, we want you to swear. We want you to take a solemn oath that you're forbidden by Scripture not to do, to tell the whole truth. My contention, Judge, is that I don't think you even know the whole truth. And nothing but the truth? And get that, and nothing but the truth? Why don't you go ask Edward Teller if he'll tell you the whole truth about physics and nothing but the truth, and subject himself under the penalties of perjury to life imprisonment? Why, he'd look at you like you're some kind of a nut. I think if he was honest at all, he'd say, we doubt very seriously if we know more than 1 or 2% of the truth of physics. The entire scientific theory is based upon experimentation. And here's a guy who wants me to tell the truth. Well, you see, the word truth in its vernacular is being substituted for the word fact. Now, I can tell you the facts about something. This technician in here might be able to tell you some facts about this camera, but I don't think he can tell you the truth about that camera. And then he wants me to say, so help you God. He wants me to bring God in as the witness. He's saying, so help you God. And it's a physical impossibility to bring God in here, because I could say, so help you Patricia Gordon. You might bring my wife in and put her on the stand and cross-examine her concerning my testimony, and she might say, no, I was there and George Gordon lied about that. Or, yeah, that's right, he told the truth about that. He gave you the facts concerning those events because I was there and I can testify to that. So this entire swearing-in dogma here is poppycock right from the word go. Feel free, if it's offensive to you, well, you can swear. I'm not saying that people shouldn't swear. I'm just saying that if you analyze by taking the sentence structure apart and taking what really is being said here literally, it's impossible for anybody to take an oath. And you sure can't do it by the authority of God. So I answered no to that question going on, whereupon the judge declared the defendant to be in open contempt of court, and the defendant again demanded all of his rights, waiving none of them. In other words, I'm setting the record. I demand all of my rights, Judge, and was informed that there would be no adjudication of the contempt or review on appeal. I'm God here, said the judge, and I'm going to put you in jail, and there is no appeal. I don't know if he's ever heard of Fisher versus Pace or not. I suppose he hasn't. The defendant was taken into custody and sentenced to 5 days in the county jail. The sentence would be suspended at any time the defendant would agree to be sworn and testify about whatever it is the plaintiff wants to inquire. Here's halt. Didn't we have this with John Lilbourne? Didn't I set this fellow up here? Let me take a look over here and see if I can find the Lilbourne case, which is over around page 458. Let's see whether or not I'm on solid ground. Grab Miranda quickly and turn over here to page 458. I've read this a dozen times and I want you to follow along because this is my position in life and I'm going to substantiate it by saying that the Supreme Court says the same thing. Perhaps the critical historical event shedding light on its origins and evolution was the trial of one John Lilbourne, who was a vocal anti-Stuart leveler who was made to take the Star Chamber Oath in 1637. The oath would have bound him to answer all questions posed to him on any subject. And isn't that what they were trying to do to me? Well, I'll concede that Lilbourne was up for, I think it was libel, and I think that's a civil matter, and I'm up here on a civil matter. It sure looks like to me, when you get down here on the bottom line, that the King's Star Chamber is in full force and effect today in Boise, Idaho, in the same way that it was in 1770 or 75 in the colonies in England. So the defendant was taken into custody and he spent 5 days in jail. All right. Now, if you'll notice on page 4, I posed about 20 or so questions there was 27 questions that I posed to the court on legal matters, matters of law, matters of constitutional rights. These are the issues that I brought before the magistrate's court. These are the issues that I'm bringing now to the district court, which is a federal district court. These questions that I posed as an example number 22. Can the courts of Idaho order the fingerprinting and photographing of a defendant without his permission, over his objection, and against his will? Which is what they did. That's my assertion. Can I prove that they attempted to do that? You bet. I've got the names and the addresses of each and every one of the police officers that were out there. They are named on the face of this complaint. And I'm going to bring them in, and I'm going to put them on the stand. I'm going to say, Officer Schmedley, did you attempt to take my fingerprints, and why? And when I get those facts out, I'm going to put a jury instruction in pursuant to Davis versus Mississippi, and let the jury know that you can't take my fingerprints without a court order. Do you see how I set that one up? Going on then, on Exhibit J, if we'll take a look, I'm on page 6 of Exhibit J, and I went through a number of these examples here, like 19, 20, 21, 22. These are the questions. These are what I consider the major federal questions that I was asking of this particular judge that put me in jail for contempt. And if you'll notice on page 7, I begin to answer those questions. See, it's on page 9 where I took item 1, 2, 3, 4, and I answered every one of those. This, in effect, then was an appeal that I sent to that judge. And you're going to say, well, do you have to do that? And the answer is no, you don't. But just because I don't have to do something doesn't mean that I won't do it in order to set it in cement. If there's an opportunity to lay the case out in spades and then say, well, why are you doing this to me? I'll give him every opportunity to correct his position, but if he refuses to correct his position, I want to document it. And this means facts, figures, testimony, evidence, documents, whatever it is that you're going to later bring into court, because this happened in November of 1982, and we're up to July of 1983, so we're looking at some 9 months later. We're filing this suit. This case won't be heard typically for another year. So we're looking at something like 15, 16, 17, 18 months from the time of the event until it's actually heard by a jury. If indeed this case is ever heard by a jury, because it could conceivably go to the Supreme Court and it could be settled easily out of court, or it could be ruled upon before we go to trial. Now, there was a mistake that I made in here, and I want to bring your attention to this mistake so that you don't make it. There was a time when I had to file, I believe it was an affidavit of poverty on the stationery of the court, and they had me fill this out. In other words, I didn't have any money to file the case, and I had to answer some questions, and I think that we're calling that Exhibit JKL. It should be Exhibit L, where it says Affidavit for Authorization to Waive Fees and Commence or Defend a Civil Action. And this is the court's own form on waiving the fees. And when I filled it out, you'll notice that I filled it out Fifth Amendment. That was an error. That should have been Fourth Amendment. And because I've made that mistake, it may come back to haunt me insofar as the civil case itself, which was an issue concerning an unpaid bill. Now, that particular civil case may be in jeopardy because of this error. I'm not sure. But I really don't care much about the original civil case. I'm really concerned about this Title 42 suit, of which this is some factual information, but it's not crucial to the Title 42 case. But that was done 6 or 8 months ago when I was a little dumber. And now I consider myself just a little bit smarter. Let's turn over here to Exhibit L. I guess that particular form is between K and L. We'll call it K1. Over here at L, you'll notice the petition for a writ of habeas corpus. This was important because when you go to jail, never come out of jail with anything less than a writ of habeas corpus or victory. Because if you do, you can only come out as a loser. In which case, you always want to count the cost before you go into battle. Now, let me give you an example. We have a young fellow who's in jail right now because he would not file a 1040 form with the state of Idaho. A court ordered him to file the 1040 form, and so he did. But he didn't fill it out Fifth Amendment. He answered every question. And of every question he answered, he filled in every blank with zeros, not applicable, or his name and address. In other words, he answered every question. As the case wore on, the judge in the case ordered him to jail for contempt of court, and he's in jail for life or until he fills out the form pursuant to the court's instruction.